Okay. It's called to order the Board of Adjustment meeting for December 10, 2025. First thing to do is pledge allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, thank you. All right. Normally we go through a conflict of interest and determine if anybody has one, but there's no cases on here, so I'm not sure that applies. The agenda today, as you can see in front of us, is really just approving the minutes from the last meeting. We also have a small package of new minutes at the back end of that you may have seen just handed out today. That is the minutes from the subsequent meeting in October 8th, because that was when we approved the orders that I guess finalized the actions we took for the prior meeting. All right, and then we have a training session today. And does anybody have anything else to add or change on this agenda? No? Okay. So then we'll, yes, correct. In fact, we ought to do that first. How do we do that? We'll swear in our new alternate member, Kurt Whalen, right? Okay. I think Kimberly has the action there, item there.
That should be on, hopefully. I, Kurt Whalen,
I, Kurt Whalen,
do solemnly swear
do solemnly swear
that I will support
that I will support
and maintain
and maintain
the Constitution and
the
laws
Constitution and laws
of the United States
of the United States
and the Constitution and
and the
laws
Constitution and laws
of North Carolina,
of North Carolina,
not inconsistent therewith,
not inconsistent therewith,
and that I will faithfully
and that I will faithfully
discharge the duties
discharge the duties
of my
of
office
my office
as a member
as a member
of the Town of Sunset Beach
of the Town of Sunset Beach
Board of Adjustment.
Board of Adjustment.
So help me God.
So help me God.
Thank you. All right. Okay, now we need to approve the minutes from the August 13, 2025 Board of Adjustment meeting. I know that I've gone over this a few times with Kimberly. We've made a couple of adjustments. Looks good to me now. Does anybody else have any issues with anything? Okay. Can I have a motion to approve?
I move to approve.
I'll second. Take the vote. Everybody who's in favor, say aye.
Aye.
Okay, we're good. Those are approved. Now, the second set of minutes is from October 8, 2025. That's when we had a short meeting. The only thing that's different on that one is down at 5.2, down at the bottom of the first page. It was the approval of the order for variance 2025-02 was moved by member Overmouth and seconded by member Jay Lucas.
Okay, instead of Jensen.
It says Jensen here, but we know it was Jay Lucas.
All right.
So with that change, I'm okay with these. Anybody else have any changes? All right, can I have a motion to approve?
I move to approve.
I'll second.
Okay, and let's everybody say aye if you approve.
Aye.
Okay. So that's the approval of the minutes. All right, it's time for our training session. And listen to, man.
Good morning.
Morning.
Appreciate you, everyone, taking the time to be here, and welcome to our new members. It's the reason why we want to have the training is have our the new members exposed, kind of, what the expectations are, what the roles and duties are, and how these hearings should occur. And I'll get with Mr. Tucker probably individually as well, maybe go over some of this presentation, come to onboarding process as well. My name is Ron Satterfield. I'm a contract planner with Anchor Point Planning, but I also serve as the town's planning director for all intents and purposes. And so you'll see me more often than not at your Board of Adjustment meetings. If you happen to come to a planning board meeting for any reason, I'll serve as staff to that. And occasionally I'm at a council meeting as well as items that our planning department handles get to town council. I was not at your meeting in August, unfortunately. Fortunately or unfortunately, however I want to look at it. But I was had recently had some surgery and was not able to drive yet, so that was why I was not here. So, but you guys did. I listened to it and I was talking to the TV screen as I was watching it. So, but you guys did a great job. And Mr. Vornum and Mr. Lucas and Mr. Habermel, you've seen this presentation before. It's very similar to what we did back in, I believe it was October of last year. So bear with me through that. But new members, I hope you get something out of it, and I hope and feel free to ask questions as you will. I'm sure as we go through this. Advancing, that's correct. Okay. All right. So I just want to first start from a legal context. Our local governments are creatures of the state, and we have no inherent power here in North Carolina. There's basically two types of rules in North Carolina, and as from the government. One is a home rule, and that means pretty much a municipality can do what it needs to do, wants to do, from a regulatory perspective, until the state says you can't. And then there's Dillon's rule, and Dillon's rules basically say the state says these are the powers you're enabled to do from a regulatory perspective. And North Carolina is more of a Dillon's rule than it is a home rule. So we're some of a hybrid, but we're more consistent with the Dillon rule state requirements. So we can only do what the state allows us to do. So what this slide here says, we are not a home rule. However, the General Assembly has delegated significant authority to local governments, those expressly granted in the general statutes, powers fairly implied in or incidental to those expressly granted, and then powers essential to declared objectives and purposes of the local government. So there's 4 types of land use decisions. The first one I'm going to speak of is legislative. This board would typically not be addressing legislative items. These are policy decisions, including adoption, amendment, or repeal of a regulation. So if we're going to amend our zoning code or zoning map, as an example, that's a legislative decision made by town council, not a decision rendered by this board. So then we have advisory. So they're not final decisions, therefore there's less regulated. And typically it's a board member, it's like the planning board. They make it, if they advise or make a recommendation to town council, whether the ordinance should be amended or whether the zoning map should be amended or whether a comprehensive plan should be adopted. Keep them, those are they serve as an advisory board.
Do they serve as advisory even in the case of a case comes before them, someone proposing a development, and they approve or disapprove of it?
So
Is that not a final decision? It's just a.
They have 2 functions.
Yeah.
So first is an advisory to town council. So if a zoning map amendment, or if we want to rezone, amend this code, this is the land development code or unified development ordinance. So if there's an amendment to this or the zoning map, or even adoption of a comprehensive plan or amendment to the comprehensive plan, that is an advisory role. They make a recommendation to council. They hold a meeting, they gather public input. They make a recommendation. That recommendation is forwarded to town council to make that final decision. In the case of a preliminary subdivision plat or a major site plan, they make the decision. They are the approving agency. But in that case, and then that's really the next item, they are approving that plan or plat. And if it's compliant with the code, they have to approve it. If it's not compliant, they deny it. But they could conditionally approve for something that's part of the code. So we conditionally approve provided that the applicant shows the 20-foot buffer as required by the code. But they can't add a condition that is not consistent with the code. So instead of that 20-foot buffer, they can't add a 50-foot buffer. So a recent example of planning board approving a site plan was the hotel in the mixed use district across the way here. That was a site plan that in staff's estimation and the planning board's estimation complied with the rules. So they had to approve it, even though there were a few neighbors here that were opposed to that. But Planning board found that it was consistent and compliant with the the Unified Development Ordinance. So they had to approve that plan.
Except for the height.
Well, the height for that was approved because there was a text amendment that had gone through the process previously, approved by council. So the plan that the planning commission received was consistent with that amendment.
Okay.
Does that make sense?
Mhm.
And then the fourth type of land use decision is really what you're here for. So that's a formal action where the decision makers apply discretion in applying an existing policy to individual states or special cases. So it's quasi judicial, means it's court-like. You guys experienced it, Ms. Hall. I know you were here at the meeting in August, and you got to feel what that was like.
I wasn't here in August.
You wasn't here in August? Okay, I'm sorry. So, but just so you were here for the amendment, for the adoption of those minutes. But you got to experience how that was. You had an attorney representing the board sitting over there. You had staff. You had an attorney representing this town, and then you had two attorneys representing the applicants for the two cases. So it was a court-like decision, and it has to be run in a quasi-judicial or court-like manner. Not all the rules of court apply, but for the most part, you're serving as a jury and a judge in the same instance there. So decisions used in evidentiary hearing means your decision has to be based on evidence, and we'll go into a little bit of evidence later, presented to you during your hearing. That's how you're gathering your facts. And there are special examples.
August was the 40th Street parking.
Yeah,
Okay,
yes,
yeah.
that was one. And then there was also an appeal of a zoning, and we'll go into appeals, I think it's the next slide or two, of a decision made by the UDO administrator on parking down on West Main at the end there. So typically the general statutes allow that quasi-judicial decision to be made by governing board, a planning board, or a board of adjustment. In this case, a variance appeals and special use permits are heard by the town of Sunset Beach Board of Adjustment. So you're having that evidentiary hearing for those three types of cases. So here we are as a Board of Adjustment. They are the general statute 160D-302 establishes the Board of Adjustment. Typically, it has to be a minimum of 5 members. Most communities do have 5 members, and alternates are appointed, and we do have alternates. Quasi-judicial procedures are required, and the general statutes do allow a planning board to function as a Board of Adjustment. Sunset Beach has chosen to have an individual, its own Board of Adjustment, which is, in my opinion, is needed because if the planning board is approving site plans or has the delegated authority to review and approve or deny site plans, and someone appeals that decision, where does it go? Board of Adjustment. So you wouldn't want them to appeal to themselves, if that makes sense. All right. So our Board of Adjustment per the code, and we're looking at section 2.4 of our UDO, says the Board of Adjustment hears an appeal of an administrative decision. That's that case on the end of West Main back in August. A request for variance. That was a potential case we heard on the parking issue in the right of way. And we've had some since I've been here, at least swimming pools and a fence, and then a deck extension or deck expansion. And then special use permits, but since I've been here, the board has not heard a special use permit case. And I've been here since May of last year.
Cell phone tower over in.
You have, but not since I've been here. So I think it was done in 22, 23 timeframe, maybe. Does that sound about right? I was not on staff at the time. All right, so who do we have as members in staff role? We have a chair, that's Mr. Vornum. And the chair's role is to call witnesses in the order set by the board's rules of procedure and standard practice. Make sure that witnesses stick to presenting only relevant evidence and limit unduly repetitious testimony. You can rule on any legal objections that are made. Chair usually votes on the case as well. In this case, we do need the chair to vote because you're one of the 5 members serving. And the importance of that is, I'll get that for variance cases here in a minute. And then acts like a judge in a civil criminal case, maintaining focus and making sure the proper procedures are being adhered to at all times. So then we have an individual board member role. That's Mr. Lucas, Mr. Hovermail, Ms. Hall, and Mr. Whalen. That's your role. Need to be knowledgeable about the process and the rules you must follow. That's why we're doing our training. This need to listen attentively and ask questions to get any clarification that might be needed. So, listen to the applicants. You need to come in here being unbiased with a decision, with a predetermined motive. Hey, I'm going to vote this way because. You don't need to walk in here with a clean, open mind and willing to hear the case. Most of the actual cross-examination of the hearing comes in the form of questions for the board members. So as you're trying to gather evidence, this is your opportunity to gather evidence. So you can ask questions, and this board does a good job of asking questions and trying to determine, is that really the variance that you need? Do you have any other options? I've heard that in 3 cases that I've seen, you guys on the variance cases, I've heard that those are the types of questions you're really digging into, trying to figure out, is this variance necessary? Assess the credibility and reliability of each witness, and then legal obligation. You have a legal obligation to conduct yourselves fairly with impartiality throughout the entirety of the hearing. And that's what I was getting at earlier. You come in here with a unbiased opinion and hear the evidence, and then your decision is made based on the evidence presented. Staff, we serve as an initial witness at an evidentiary hearing. So what that means is we're presenting the case as we know it. We'll go through we prepare a case summary. You get a copy of that, as well as the applicant gets everything that you get, and we provide you everything that they've submitted. So we're going to present the case and just present the facts as we know them. The property is zoned this, the setbacks for this zoning district are X, it was annexed into the town on this date, those kind of things. We try to stick to the facts of the case and not formulate an opinion. And we do not provide a recommendation. And why is that? Is because what we recommend doesn't matter. It's your decision based on the evidence presented during this hearing. Does that make sense? So we do summarize the application and then recount any staff analysis of the application. And then sometimes we will have an attorney here. And for attorney's role was for the parties to handle presentation of evidence and to question any opposing witnesses. You saw that back in August. The board will often have its own attorney to guide and to provide some legal advice, guidance through the process. You've seen that on a few of our cases. The attorney will organize, present, and summarize the case as well as make legal arguments. They generally do not testify to personally present factual evidence. So they're not the one presenting the evidence. Typically, they may call a witness and then ask the questions of the witness to provide evidence. And then if attorney does testify about the case, the facts of the case, they're treated the same as any other witness and should be placed under oath and be subject to appeal, or cross-examination. So the first type of case, grab a sip of water, that you may get is an appeal, and you've seen one of those recently in August. That was, again, the one of the parking situation in West Main. So the case must be appeal of an actual official staff determination or action and not of an advisory opinion. And what does that mean? Well, in this case, someone could ask, what do you think about this? And we could send, maybe staff gets an email. I'd like to do such and such on this property. And we say, well, that use is not allowed in that zoning district. Response via email. That's just an advisory opinion, not an official letter. If they want to appeal it, they would ask for us to prepare an official zoning determination of whether they can or can't. And that's stated. That was done in that parking case. You may recall you had an official letter from the zoning administrator, UDO administrator, that said this is the town's determination and this is why we made that determination. They disagreed. They appealed it to you. An appeal must be brought by a party with standing. within 30 days of notice, and that's what you received on that one. They waited till, I think it was 29 or 30 days, but they met the standard. And then appeals may also include a neighbor appealing the issuance of another neighbor's permit. So the appeal, we're looking at clear objective development regulations desired, but they're not always achievable. Sorry, I need to advance the slides. No UDO is perfect. And we experience that almost weekly. And we scratch our heads, well, what is the intent of this? So we have to make a determination. But that's what this board is for. It's kind of a check valve. You know, you're hearing cases from your peers because every one of you are a resident of the town or the ETJ, whichever may be the case. So it provides a way for that code to be verified and fact checked, if you will. You know, staff making the right determination and right interpretations on these. And for an administrative decision to be appealed, a written final determination must be made. So a formal notice of violation, a decision on a permit, a formal ordinance interpretation, or any other written decision, which I've kind of covered on that. So appeals must be heard in a reasonable time and notice is required. I believe our code says 60 days from the time of the appeal. We try to do that sooner, depending on availability and how much fact gathering we have to do. We have a unofficial deadline of about 30 days prior to to your meeting. So 30 days ago from today would have been the deadline for any items for today. Your next meeting, second Wednesday of January, I believe the deadline was this past Friday. It's not an official deadline, but the reason we have that deadline, it gives us time to review the application for completeness, let the applicant know whether or not they still need to provide any information, and then also start to do our own research and analysis, and then advertise properly, whether it's posting signs, sending notices to the paper, joining property owners, whatever the case may be. There's a due process requirement that we have to, so that's the reason why it's kind of a 30-day window of appeal, of getting an item on. So the official whose decision appealed must provide relevant documents to the board, and the appellate must be present at that hearing. And then your role is to reverse or affirm in whole or part the appeal decision. And then parties may agree to mediation or other alternative resolutions. And then once your decision is made, we prepare an order. I'm going to maybe a little bit more detail later. Written order is approved by this board, signed by the chair, is then provided to the applicant. And then their next step is to the court process if they choose to. Yes, sir.
You said you can move to a negotiation of some sort?
It says parties may agree to mediation or other alternative resolution. So we can get involved and sometimes usually it's attorneys involved with that, or the town does this, the applicant will do this kind of thing. We can't waive the code standards, of course.
Right. It's just trying to determine where and when that would happen. Sounds like it happens outside of the meeting, right? Okay.
Outside the meeting, remember, I think it's in my 30-year career, it's happened one time in another jurisdiction that I worked in for a while. But it was very rare.
Okay.
And hesitated even bringing that up because it is a very rare process. But it is my effort trying to be transparent. It is something that can happen. Similarly, any other court proceeding, mediations can occur.
Right. Okay.
Let's talk briefly about standing. So standing is any person who has, standing is important because they're the ones who can appeal a decision to the Board of Adjustment. So we're looking at the owner of the property or someone with an option to purchase. So you own that property and the town says you can not do what you want to do, then you would have standing and you have a right to take that to the Board of Adjustment. Any other person who will suffer damages as a result of the decision being appealed could make a case for standing. And then a neighborhood association, property owner association potentially could make a case for standing. Staff doesn't make that decision. We can't come in and tell, well, I'm sorry, you don't have standing, Ms. Hall. You can't appeal that decision to the Board of Adjustment. That's the Board of Adjustment's role,
right,
is to determine.
In our last meeting, that one case on parking, why was that not why did that even come before us?
Which one?
The one that the gentleman was
On
trying to.
Sixth Street.
Yeah,
The parking?
right.
Well, that was part of staff's argument, was that they didn't really have a case, but we couldn't make that determination. We told them that we didn't think they had a case, but we could not. They wanted to move forward with the application.
That was their
Yes.
decision to move forward.
Yes.
Even though the definition of it was definitely contrary to
Yes,
their.
yes. We advised them that we didn't believe that you guys had authority to review it. Our attorney advised their attorney of the same, and they wanted to move forward. And ultimately, we have to process it because they wanted it processed.
Okay, all right,
So we made the determination they didn't have it.
you're right.
Right.
His attorney should have made that determination too.
And then the unit of local government that has made the decision being appealed, of course, has standing. And the standing is important for participation of third parties in any other quasi-judicial hearing. So I want to, is there any other questions about appeals? If not, I'm going to transition to variance. I'm glad you guys actually had the experience, got the opportunity to
Right.
experience an appeal, because I think this makes a little bit more sense now.
Right.
And that was a very difficult case for you guys, I'm sure. You know, it was
West End.
the West
the
End
West
lane,
End.
yes, yes.
Yeah,
That was crazy.
40th.
It was an
by 40th.
interesting case, though. I mean,
Yeah, it
like I
was.
said, I was watching from TV and I experienced it here and was involved with a lot of, I prepared the staff report and so forth for it. But I was watching on the computer and then yelling at the computer and, you know, asking questions myself, you know, kind of things as I was kind of sitting with my legs propped up because of my rehab. So a variance is gives the board permission to modify any provision of the ordinance to prevent unnecessary hardships where, first, it's an unnecessary hardship or result from the strict application from the regulation. The applicant does not need to demonstrate that in the absence of the variance, no reasonable use can be made of the property. That was added in the last 10 or 15 years or so, that last statement to the statutes. So you're looking at, you should be considering that the hardship that's being requested is peculiar to the property, such as the location, size, topography, hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. The last sentence there is about reasonable accommodation for Federal Fair Housing Act. We've not processed one of those. I won't go into a lot of detail on that. And if we ever get a case of that, we'll talk more. You'll have more information in your packet and so forth about that. But that's you know, basically saying you can't discriminate against housing and so forth decisions. So the third of four is the hardship did not result from actions taken by the applicant or the property owner just because they purchased the property, not knowing that the property was owned such and such, and they knew this is what the setback were. May not is not a self-created hardship. So just because they knew it doesn't mean that this is self-created hardship. And then the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that the public safety is secured and substantial justice is received. Yes, sir.
We go back to the first one.
These?
And it's not necessary to demonstrate the absence of a variance, no reasonable use can be made of the property. So they don't have to demonstrate that.
Right.
But isn't that often the case though?
Well, let me add an example. So someone that we've gotten several here, and I continue to talk to folks about swimming pools. Someone who may want to put a swimming pool on their property. Well, they already have a house,
Right. They're making use
so
of the
they're
property.
making use of the property.
Right. Got that part.
Yeah. So that's the purpose. So you couldn't use that to say you're already using your property, so therefore we can't grant the variance
Yeah.
for the swimming pool.
But there are cases where you could zone something into inutility if you apply the zoning requirements precisely the way they are intended to, based on that particular property. I guess we haven't seen that yet.
You haven't
here.
seen that, no.
No,
And
okay.
and what you can, and I believe it's on, I don't know if it's one of my next slides or not, but yeah, here's the next one. You cannot give a variance for a change in use. So if the property is zoned and a retail store is not allowed in that zoning, you cannot hear a case for a variance to allow the retail store. That's what a text amendment is for, or that's what a rezoning is for. So
Goes to the council.
yes. So you can't just say, okay, well, we think you should be able to put that retail store there, so we're going to issue a variance. A use, it's what they call a use variance, and a use variance is allowed by statute. And then we recommend that you vote on each one of the 4 provisions individually, which you do. You go through each one of them, and you have to, for that variance to be issued, all 4 have to be found. Not just one of the 4, or 2 of the 4, or 3, 4. All 4 of those have to be found for that variance to be issued. And we've had cases where the board says, well, 1, 2, and 4 are fine, but we have issues with 3. Number 3. But so just keep that in mind as and you guys, I know you 3 have done that already, but all 4 of those have to be found in order for that variance to be issued. And it requires a 4/5 vote. And I believe that's on one of our slides, and that's the purpose of having at least 5 members.
I always just keep a checklist of those 4 points and,
It's good.
you know,
Yeah.
okay, make sure you hit that point,
Mhm.
And if they miss any, then we're not there yet.
And once you guys in the public know who may be watching this meeting, whenever I'm meeting with someone who may want a variance for an item, I'm going through the code with them. I'm talking to them about the requirements, and that I'm telling exactly the same thing I've told you guys. It has to be a 4/5 vote. All 4 of these have to be found. I will guide them and help. I won't use the code. I won't coach. I won't say I coach them, but I will provide them information that may be helpful or not helpful. As we're, I want to give people the benefit of the doubt, because most of the folks going through this process don't even know what a variance is.
Right. So,
And what they expect, because they're not attorneys, they just want to build a shed, or they just want to put in a swimming pool.
so
they
you actually give this to them? Or,
I don't give the presentation, but I give them the
no,
code
I mean,
citations.
the variance,
Yes.
the four
Yes.
different issues.
I do.
Because I've found that when they do come to us, they don't talk about that. I mean,
Yeah.
they don't, that's not their
Yeah.
discussion, and they should.
It's not, well, we do provide the importance. I mean, I can
Okay.
tell that.
All right.
And
As long as they know that.
I want to give good customer service. And I always think of a family member who may walk in and never, they don't know what a variance is or why they have to do, so I want to provide as good a customer service as I can. And even if it means I've got to spend 30 extra minutes with someone sitting at, in a conference room, going through the standards to make sure they understand when they leave. What they do with that information though afterwards is, I can't make them address those issues. And people clam up too when they get up here too, or they don't understand the importance of having to do this. So what I have done, I met with someone last week, I've encouraged them to, and they had some exposure to waive the variances in another jurisdiction, to watch one of the Board of Adjustment cases and kind of see what was, how this discussion went, and maybe it'll help them when they come before you, be able to better prepare themselves and provide evidence. But variances are intentionally by the state, not intended to be just be granted frivolously. I mean, these rules are the state rules, not Town of Sunset Beach rules. So if you go to pretty much any county and any municipality that has a zoning ordinance, you're going to see these almost word for word, these same findings of fact, or these same 4 standards, if you will. And so they're guided by the state. And I always let the applicants know that as well. These aren't 4 rules that Town of Sunset Beach came up with. These are rules that are governed by the state. And I also emphasize that you are peers of theirs. You're all residents appointed by the town council. So you're just like they are, a property owner in the town, resident of the town, or the ETJ, whichever may be the case. Just taking the rules and applying them as you deem appropriate. The next one are special use permits, and again, you did have a cell tower a couple 2 or 3 years ago. I was not here when that happened, so I've not experienced special use permit with you guys. I've had many special use permits in my career. So I think of a special use permit as a use that's allowed in the district, but with special provisions, and it requires this evidentiary hearing. So without these standards, it wouldn't be allowed. But it also it requires this evidentiary hearing so you're serving to make sure that all the prerequisites are in compliance, but also that it's not going to be a detriment to the neighborhood, that it complies with the plans, that overall doesn't impact property values, those kind of things. So it is not a use by right. I mentioned the evidentiary hearing is required. We do notices to the neighbors, signs are posted, it's advertised online, advertised in the paper, I believe, in most instances. But it's also not a public hearing to hear the opinions of the public. Your decision has to be like a variance and like an appeal. Your decision has to be based on evidence and factual testimony presented to them. So the decision must be based on the standards in the ordinance. The burden of proof is on the applicant first to show how they comply with those standards. And if they have satisfied those standards, then the burden shifts to anyone who may be opposed. Ultimately, if you find the evidence presented shows the standards have been met, you must approve that special use permit. Similar to the variance, you must approve that variance if you find those 4 factors are met. If contradictory evidence is presented, the board must first find that the standards are met or the permit must be denied. So you may hear, you probably heard it on that cell tower case.
Oh, yeah.
Some folks, I'm sure the applicants came in with their
Read it live.
attorneys. Yeah, I'm sure
Always
the attorneys, I'm sure
Yeah,
the
always are.
applicant came in with their attorneys and they provided you, they had all the I's dotted and the T's crossed. And then you had the public here stating why they didn't think the cell tower, most of the time was they didn't want to look at it or they felt like it was going to be, just detrimental to their health or whatever the case may be. But ultimately, I guess you guys found that y'all approved that one, correct?
We approved it, but it never got built because I think they had stormwater permit problem.
Gotcha.
But that wasn't our problem, that was theirs. They did a really great, the applicant did a really nice presentation, because I've done that stuff before.
Right. I found most of the time, a special use permit for a cell tower, their applicants, they come in with their attorneys and they've done their homework and they know how to proceed with these, because a lot of jurisdictions require special use permits for them. So just to list a few uses in your town ordinance that requires a special use permit. So we're looking at multifamily in our MR3, MB1, MB2, and BB1 zoning districts. Adult establishments in the MB1 district, body piercing and tattoo parlors in the MB1 district, hotel, motel in the MR3 and the BB1 zoning district. I'm not listing them all. I'm just kind of randomly selecting. An indoor-outdoor shooting range in your MB1 zoning district, large utility services, your cell towers, storage facilities, self-storage in your MB1, MB2, and your MUD districts require a special use permit. So if anyone comes and wants to do any of these uses as applied in this in those zoning districts, that's when you would see an application for that. But I was not exhaustive of the list. I just randomly selected a few. So just kind of summarize. Decision must be based on the standards. I'm sorry. So here are the 4 factors. Is the use will not materially endanger the public health, safety, or general welfare if located when proposed and developed according to the plan as submitted and approved, similar to a variance case. The use meets all the required conditions and specifications. And in our code, the way it's said, there's certain standards that apply generally if someone wants to build in the town. But also there's what we call conditions, what I call prescribed conditions or use standards in the code. And those use standards also have to be shown how they can comply with those use standards. So not just, so your regular code provisions as well as any specific use standards for that particular use. So you're also finding that the use will not adversely affect the use or any physical attribute of adjoining or abutting property, or that it is a public necessity. So you're looking at basically how the property value is being impacted negatively. And then the location and character of use is harmony with the area in which it is to be located in general conformity with the town's comprehensive plan. And we'll emphasize both on the variances, and you could even say appeals, the variances, special use permits. They're all just discretionary review. So in the special use permit case, the meeting all required conditions specifications is probably pretty objective. We can check a box and say, okay, yeah, they meet the setback, they meet the height, they meet the buffer standard, they meet the impervious surface levels. That's subjective. But the other three are discretionary, subjective. And that's what kicks that into an evidentiary hearing, board review. Staff does not have the ability by law really to make decisions on when there's subjective or discretionary review. So impacting joint property values, that's, you can have evidence presented both ways. You know, so they have a board, like a board of adjustment, and that quasi-judicial evidentiary hearing process to make that decision. So special use conditions, you are allowed to place conditions on special use permits. The statutes, though, are real clear, and they've been our code. The code mirrors those statutes. You cannot place conditions on taxes or impact fees or building design elements for single family or two family residential. You can't say the home has to be brick, as an example, or we stay away from driveway related improvements in excess of those allowed in the general statutes, and then any other unauthorized limitations of land. But you can place conditions, and those conditions need to be reasonable and appropriate. Conditions that run with land must be consented in writing. Time limits are permitted. And then conditions may be imposed which require that one or more things be done before the requested use can be initiated. So like a solid board fence be erected around the site to a height of 6 feet before the use. And that's for special use permit, not for variances. Very rarely do you see a condition placed on a variance. And never, hardly, I can't think of an opportunity one like you would do it for an appeal. Is any of this making sense? And then code spells out a condition of a continuing nature may be imposed, and the example is loudspeakers not used between the hours of 10 p.m. and 9 a.m. Those examples taken from the code.
So this board wouldn't have the ability to place those conditions.
You do have the ability to place some conditions, but there are conditions
Would you as
They're
a
on special use.
for special use permits.
Would y'all recommend those prior to us taking a look at them?
Typically we do.
Okay.
We'll come in and as we're doing analysis, we'll provide, hey, we think this condition, let's increase the buffer from, I think to me it's an easy example, from 20 feet to 25 feet to provide more protection on that north property line because it's adjacent to single family residential.
Got it.
You may see a condition like that or a height limitation or those kind of typically we would provide recommended conditions that you can, but the applicant may not agree to, and that you may.
But we can make those conditions part of the agreement.
A typical one that I used to see is with cell phone towers, fall radius.
Right.
If the tower falls down, it doesn't fall on somebody's house.
Right.
So they have to demonstrate that they can.
Right, then they can comply with that. I believe the town's rules has a fall radius, or some demonstrated calculation on what the fall radius is. I don't remember exactly what it is, but a lot of times they are spelled out in the code. And cell towers, though, in the last couple of years, the state government, has even further to limit what can and cannot be considered during the hearings. So, like the electromagnetic.
That's federal government.
Yeah, federal. We can't.
That's
At
right.
one time, we heard a lot of neighbors would come out against it because of that. The boards would use those as reasons to not allow them. But federal government stepped in, local government, state government stepped in too to limit some things. But yes, Mr. Lucas, yeah, we would analyze and provide some recommended conditions that we see on our side. Now, granted, understand that we're not privy to the public hearing or to the hearing and hearing the conversation that may occur during that hearing. And so you may come up with additional conditions that you believe is important in issuing that. And if as long as you're not touching these kind of conditions, we can guide you on those.
Got it.
So it's going back to a little bit on quasi-judicial procedures. A quorum depends on your local ordinance, simple majority or 4/5. So it's important when you hear a variance that we have at least 4 people here because it takes a 4/5 vote to approve it. And that 4/5 number is 80%. So if you have 4 people here, and only 3 of you voted in favor of that variance, now you're looking at 75%.
Got it.
So, and that's why for easy math purposes, that's why a lot of Board of Adjustment are limited to 5 serving members with 1 or 2 alternates. Those alternates to serve or would sit in place of a regular member not being here. So voting requires us that 4/5% for a 4/5 vote for a variance. It's simple majority for an appeal and a simple majority for a special use permit. And if we have a vacant seat here, we'll then figure out how that, don't worry as much on that last part of that slide bullet. We'll figure out, does the seat count, if you're here absent from the meeting just because you couldn't make it versus the seat is unfilled because there's no one to serve, it matters on how that's done. And we would consult with our attorney to make sure we're counting the votes correctly, if that makes sense. And then your hearing, I've said this several times, but we need to reiterate, it is an evidentiary hearing to gather facts. It's not a public opinion. It's hard to take that hat off because you're probably a good chance you know someone that's sitting out here, particularly in a town the size of Sunset Beach, who may be opposed to this item. But your decision has to be based on the evidence and the facts presented to you during that meeting. Again, that's why we don't make a recommendation, because I could recommend something all day long, but my recommendation doesn't matter to what you're hearing, ultimately what you have to decide. So we do have a detailed record of the hearing, including detailed minutes. You just approved a couple of detailed sets of minutes. Sometimes they're verbatim, and I believe in this case they may have been verbatim or darn near close to verbatim.
Yes.
And then the hearing for each case must be open and closed. And you hold case 1, you open it, hear it, close it. And then you open case 2, hear it, close it. We do sworn testimony. If you haven't watched that August meeting, you're gonna need something to do. I mean, I advise you guys, two of you particularly, to go review that meeting.
Yeah, I watched it.
So the witnesses' evidence must be presented under oath, and cross-examination is allowed. The BOA chair can subpoena witnesses if we need to have a witness subpoenaed. The chair or the clerk can administer those oaths. Findings of fact are required. Where there's a conflict of evidence, the board must specify what it determines to be the facts that are basis for the decision. And what I try to do, and you guys have had my case summary a couple of times now, correct me if I'm wrong, but I try to have a facts section at the end, just facts as I know it. Again, property is located here. Here's what the zoning is. The request is, they've requested a variance from the 5-foot setback to allow, up to 2 feet, from the property line. Here's what so I try to outline what I think are facts of the case. I try not to make any conclusions. And there's a difference between a fact and the conclusion. Because you guys are now making conclusions based on the facts of the case. So there are conflict of interest rules. That's one of the reasons why it's on our agenda every time. So in the conflict of interest, we want to make sure the applicant and anyone involved in the process has an impartial judge and jury. So if there's some, and I believe there's a slide here, but is there any financial hardship? If you have a relationship with a familial, a member of your family, or there's some money opportunities for you to
like your neighbor, you know the person. You're coming and you're close to them.
That's for the board to determine. Certainly you can let us know that and we can try to make a case for it. But if you feel like you can't make an impartial decision because it's your neighbor, this board needs to know that, and
You
may
need to
have to
accuse yourself.
recuse yourself. You know your neighbor very well, and they're going to do the right thing, or they're whether they're not going to do the right thing. They need to have an impartial decision.
Right.
So all meetings and deliberations are open to the public. Deliberation decisions can be separate from the hearing, which means, but they're still open to the public. So it means you might hear the case today, next, and you've got all your evidence, and you've talked about it, but you want to further deliberate it. You can continue it to another hearing, another date. But every deliberation, every bit of conversation needs to be held in the public. There's no reason for this Board of Adjustment to go into a closed session. I've heard of jurisdictions, take a 15-minute break. because you've been sitting here for 3 hours and you just need to get a break and go out in the hallway or whatever. You don't talk about the case. I've heard of jurisdictions where that happens because it's hard, to be standing around, getting a sip of water or whatever, and that's what you guys have in common here at the moment. It's hard to take that, to not do that, but you can't do that. So anytime, and that goes this, anytime majority of the board gathers in person electronically, it's an open meeting. Full and accurate minutes are required. Closed sessions are limited. I can't think of a time where you would go into closed session. And then avoid discuss public businesses at social gatherings. You send emails. If you make it in fact, a couple meetings ago, this when Mr. Larry was still chair. He received an email from an applicant. He sent it to Kimberly. He didn't respond. He said, you're going to get emails occasionally because the public doesn't know if they can't contact you. We try to tell them, the applicant, when they come in. In fact, I do tell them when they come in, they can't contact you. But the neighbors don't know that because I haven't had the conversation with the neighbor. They see the sign go up, they know that you're on the Board of Adjustment, so they want to talk to you about it. So you get an email on a case, you can say, you can send it to us or copy us on your response. Say, sorry, I can't talk about this, but I've sent it to staff. Maybe they can provide your response. So a little bit about evidence. Must be substantial, competent, and material. And it's entered into the record and kept on file. So I believe in the last hearing, this is Exhibit 1, this is Exhibit 2, or Exhibit A, B, however it was labeled. Hearsay and non-expert testimony cannot be the basis for a decision. And what would be non-expert testimony? Your neighbor getting up, the neighbor, the private getting up. Well, I know this is going to impact my property values. How do they know that? Are they qualified? Or traffic is going to be a nightmare. How do they know that? They're not an expert on that traffic. They experience it. And they may be right ultimately, but they're not an expert to determine that. So you should not gather evidence outside the hearing. And ex parte contact is not allowed. That's a tough one for folks.
Yeah, the ex parte I can understand. But,
Evidence outside the hearing.
What's your opinion on if there's a variance request for a particular property, visiting near the property to see what it looks like in person, so you know what we're talking about?
Well, I believe Mr. Richardson would tell you don't do it. He's the attorney. Whenever we need an attorney on the cases, he would advise you not to do it. You're in a small town. You're going to probably drive by the property anyway. If you drive by it, I would disclose it. I would not stop and get out of your car and walk the property. Why is that? Well, the property owner may be there and that person may want to come out and talk to you about it. Or the neighbor's there, they want to come out and talk to you about it. Then that's where the ex parte ex parte contact is really questionable. In its surface, I don't think ex parte contact is illegal, but it has to be disclosed. So if you do drive by it, I would advise you to let the board know, because that's the evidence gathering. I drove by it and I noticed that that tree had already been cut down. Or whatever the case may be.
Yeah.
It's on your way home. You can't miss it.
You can't miss it. I mean, like I said, you're in a small town, and you probably know a good portion of the people who may be here opposed or in support of an item. You go drive by it because it's where just how you drive. It's on the main street, whatever the case may be. Or it's in your neighborhood. Maybe not be a neighbor. You may not even know who they are, but it's in your neighborhood. I mean, you're going to be exposed to that kind of thing. But I do believe Mr. Richardson has advised that he prefer you guys not drive by. But if you do, I would just disclose it.
Yeah. I actually did that the first meeting.
Yeah, and that may be what I'm thinking.
Yeah, and that was the one on the fence in the swimming pool.
Yeah.
Yeah.
Yes, I remember that now. Maybe
But I
that's
did
why I'm
disclose
thinking.
it. I disclosed it. So.
I'm thinking that's why I remember him saying he'd prefer you guys not to. So I've said this many times with the underlined section there on the screen. Only the evidence presented at the hearing and subject to cross-examination should be considered. So if you drive by and you notice something, you don't disclose it, but that's what you base your decision on. Then the board is not, the other members of the board aren't privy to that, nor is the applicant who's requesting that waiver, variance, special, whatever the case may be, is privy to that. So that's the importance of disclosing it. And going back to the emails that you may receive, you don't need to consider those in your hearing. So competent evidence, not include the opinion testimony of lay witnesses to any of the following. So the use of property in a particular way affects the value of other property. So you may come in, like the applicant may bring in an appraiser and say, we've appraised this property and we've used such and such comparables and blah, blah, and this is what our conclusion is. They certainly don't have standing, but they're a lay witness or they're a witness, expert witness to that. Increase in vehicular traffic resulting from proposed development poses a danger to public safety. So that's where an engineer, traffic engineer may come in or be hired by the applicant on a case. Most of the time, you're not going to get that kind of thing on a variance case. Maybe a special use permit, depending on the nature of it. Most likely not on an appeal. Matters about what only expert testimony would generally be admissible under the rules of court, rules of evidence. So this kind of goes back to the conflict of interest. So we're looking to come in with a fixed opinion prior to the hearing. And Ms. Hall talks about your neighbor example. So I know the neighbor well, and he or she is going to do a great thing. The request isn't too bad. If you can't come in here with a partial, without a fixed opinion, then I would just say disclose that to the board and let the board decide whether or not you should be recused or not. And if you know that in advance, let us know so we can prepare to have maybe an alternate,
Right.
so we can hear the case. No, I know. I'm just you asked a question about, so I'm going to use you as an example.
That's the only reason I could think that,
Right. So then the undisclosed ex parte communication, a close family business or the relationship with the affected person, and then certainly any financial outcome, interest out in the outcome. So you're the real estate agent that has it listed. Probably shouldn't be sitting as the board of adjustment for that member for that particular case. And then if any objection is raised, and I've seen it where attorneys have said, I believe Mr. Vornum has a conflict of interest and this is why, and you refuse to recuse yourself, then the board makes that decision. So parties withstanding have the rights to present evidence, cross-examine, inspect documents, and object to testimony and evidence, and offer any explanation rebuttal. Again, we talked about the attorney may represent the party and act on the party's behalf. North Carolina State Bar ethics opinion is that non-lawyers may not provide legal advocacy. Kind of what I'm doing right now, though. So it's a lot of times we're not going to have the attorney here for a case. We haven't had them for every case. We've had them for cases we feel like we need the legal advisor here. But we can guide. Architects, engineers, surveyors, and any other land use professional can participate as a witness and provide evidence in support of their clients. But that traffic engineer, as an example, shouldn't be the one cross-examining or making any legal arguments or examining evidence. The applicant can do that, or the attorney can do that.
Well, then they're also subject to our questions.
Absolutely.
Examiners.
Absolutely. Okay. And if the neighbors or anyone opposing party has standing wants to ask that professional expert
Correct.
opinion, what they think, cross-examine, they can certainly cross-examine that appraiser or that engineer, surveyor, and I've seen it happen. So burden initially starts with the applicant and then shifts to any opposition. We've kind of focused on this deliberation. It's open, focus on the applicable standards and based on the evidence in the record. And I think this board does a good job. I've seen you process the variance and taking each one of the four factors. Guys, what do we think about this first one? What do we think about the second one? Maybe the third one, and take a vote on each one of those. So sample findings of fact, these are coming back, what I try to make sure we include in the case summary, staff report you receive. So I'm going to go through each one of these, but This is kind of the information you may see in your packet if you get a case for a variance or an appeal or for a special use permit from us. Conclusions, you guys make the conclusions. So the hardship is self-imposed because hardship is not the result of site characteristics common to all commercial properties. So those being a conclusion that you guys, and the board makes. So the findings of facts, conclusions, we're looking at must be in writing, must be signed by the chair and authorized member. Explain the logic behind the decision, and then typically staff or the attorney will prepare those. I have prepared a few for this board. I believe the attorney prepared the last two, the August case. And we will get those prepared. We typically jump on those fairly quickly and get to the board for approval. And because that's once they're mailed to the applicant, that's when the clock starts for any appeal. So typically can be approved by the chair. Statutes, still debate a little bit what the statutes read. Should we hold the Board of Adjustment meeting for the approval of those orders, or can we just run it by the chair for the chair to sign? That's debatable. So
It's our typical practice.
we've done it both ways. For the last two we did, because of the nature of those cases, we wanted to make sure they were approved in a Board of Adjustment setting for the entire board to vote on them.
I would prefer that.
So it's not the wrong practice. It just may take longer to do.
Gives you
I guess, that way you all know.
Yeah. But I guess nothing else. If that's preference, we could always hold a special meeting for something. If we felt like something was pressing, we needed to, get that order signed and to the applicant sooner than later.
There's a time limit on when you have to get that out.
Not necessarily, but the appeal process doesn't start until it's signed and delivered to the applicant. So there's a motive for us. Town should be motivated in getting it done sooner than later.
That appeal would go to Brunswick County Superior Court.
Yes. Yes. What we don't want to do though is wait 6 months to hold a Board of Adjustment meeting, because until we have the next case. Because you guys typically are meeting only when we have cases, an item to discuss. So we can figure that out administratively, the best practice on that. So testimony and evidence considerations. How should non-expert testimony be handled? It must be ruled on by the chair, typically be heard, but cannot be basis of decision. That's when you get the neighbor up and says, hey, I don't want them to build that swimming pool so close to my property because, well, is it really expert testimony that they have standing? That's the decision you guys need to make on that. I mentioned this bullet earlier. Really, staff doesn't make the determination someone has standing. That's up to the board. We can advise and we can provide an opinion to the person like we've done in the past. Let's see. So procedurally, chair opens the hearing, witnesses are sworn, staff gives a summary, applicant presents their case, and then provides any evidence. You guys can have questions. Cross-examination is allowed. And anyone who may be in opposition then gets a chance to do the same. Applicant is offered in time for rebuttal. The objector's rebuttal. Chair summarizes evidence and excludes any hearsay opinion. You can ask questions throughout the process, of course. And then deliberation, determinative facts, conclusions, the motion to vote, and then the hearing's closed.
Okay.
So you guys have heard you three have seen this example before, so maybe don't answer this one. So here's a sample question. You're considering a variance petition. The neighbor appears at the hearing and presents a petition signed by 50 other neighbors that opposes the variance. Can the board consider that petition? I'll kind of look at you two for this one, since you've you've seen this one. And this is, you will get something like this. Neighbor comes in and says, here's a petition signed by 50 of the neighbors who oppose this variance. We want you to
I would-
consider it.
I would say no.
I'd say no too.
Yeah, the answer is no, because you cannot consider the petition to be evidence.
Right.
They don't have standing.
Relevant matters consider the facts of the case and whether the request meets the ordinance requirements for the variance. Those people, the names on that petition, likely don't have, a lot of them may not have standing,
Right.
but they're also not here to be cross-examined.
Now, what if they showed up?
If they showed up, they could speak, if they could prove standing and keep things relevant to the case at hand. And that's where it's important for the chair to make sure that it's not repetitious.
Right. Or the
Um,
experts. Yeah.
I've seen some
always a lot of fun.
jurisdictions, they try to place like we'll give 20 minutes on each side to present their case,
Mhm.
which you want it, but I would advise not doing that for an evidentiary hearing, because the next person who may have been minute 21 may have the evidence that's needed to support or not support that variance. So the chair has to do a good job on judging whether that's hearsay, relevant, competent, substantial evidence. Repetitious. You don't need 10 people getting up and talking about how it's going to impact property values or
Yeah.
removal of trees or traffic impacts or whatever. One person's fine, provided it's factual evidence. So the chair can ask for non-repetitious testimony, but I would advise not setting time limits on an evidentiary hearing. Planning board can do it for their type of cases. Town council could do it should they choose to. But for an evidentiary hearing, I would advise not setting time limits. Some jurisdictions do it, but I would advise not. So another sample question, you're considering the variance, and it will cost an extra $3,000 construction costs to get a driveway in to avoid some wetlands on the site and still meet the setback requirements. So the setback variance is requested that we reduce those costs to $1,000. Is that a relevant fact that you need to consider?
I think so.
Hmm.
Thank you.
So in general, the cost of construction would
Would
not be.
not, yeah.
But because there's wetlands on the site, maybe they should use that as the reason
I was gonna say
for the
too.
wetlands for that setback issue. I don't know, just there's things in that statement that could be used potentially for the Board of Adjustment to
Well, with the
consider.
wetlands, when you have to get through the state.
State or the fact that, okay, if I can't put my house over here because of the wetlands, but so to stay off the wetlands, I need to push it
This way.
5 feet from the property line instead of the 7.5 feet as required by code. That may be
Mhm.
something the Board of
Right.
Adjustment could use in
Yeah.
the case, but because it'll save them $2,000 in construction is not a reason to consider it. Does that make sense?
Yeah. Mhm.
Money is not a consideration.
Exactly. And something like that, if I met with that applicant and they told me they have wetlands, or in my research I found they have wetlands on the site, it would be disclosed first, and also I would have had that conversation. The money doesn't matter, and maybe you could use this wetlands to help your case.
Right.
I would advise them on that in that regard. So that's my presentation. You guys have sat through it twice now. Thank you.
Good. Appreciate it.
Okay.
Yeah. No, it was good. I
Good
like that.
reminders, that's fine.
But if you have any questions, feel free to ask.
Can I get a copy of it?
Yes, I will have. I didn't want to give them to you today just because a lot of times people spend time looking at that instead of listening to the presentation. But we can get them posted and send them email out. I'll get them to Kimberly.
Just email the file.
I'll give them to Kimberly to email them.
Put them online. Put them online.
Email would work, so
Mhm.
we don't kill another tree.
Yeah.
Yes, yeah, that's fine. I'd be glad to email them to you. Maybe we can even attach it to this. I want to post. Can you attach something post meeting as an attachment?
These all have history. We get a copy of the summary of facts before the
Yes.
meeting.
Yeah, typically you're getting them. Your meeting's on Wednesday. We try to get them to you at least a week in advance. Maybe it's the Thursday before the meeting. You get the case summary. You get the applicant's information, the application, any evidence or anything they have provided so far. pictures, whatever we receive as a packet from them, we give you. So, and we also send them the same thing we send you. So everyone's walking in here with the same materials. So, you have the opportunity to read through it, but make, as we stated, don't have a fixed opinion walking in. There's no way I'm going to grant that variance, or heck yeah, I say this is that they check all the boxes. We need to go ahead and issue this one. So just walk in with an open mind, not in a fixed opinion, willing to hear the testimony on both sides. Some cases are going to be pretty short. Other cases are going to be fairly long.
And
I think having materials in advance is very important, personally, and I think it all helps you develop questions to be asked. Absolutely, because there's things in there you may not understand, or there's why would you do it that way kind of question.
Right.
But the applicant's not constrained to what they presented to you before the meeting. They can
To
add
me.
to it.
Yeah, they can add to it. Yes.
Right.
Correct.
So at the hearing, if they didn't give
Right.
me
A witness.
all the pictures that they want, or the
Right.
witness, in fact, we don't want witness testimony in the packet. We want them to come hear it during the hearing. So we try to remember. I'm not always good at this. To enter this after at the conclusion of my presentation, and say we'd like to enter the staff report into the record. It's kind of a foregone conclusion because if the courts asked for the record, they would get a copy of it anyway. But we try to remember to officially enter that case summary and staff report into the record. So yeah, you do receive packet, and anything we get from the applicant, you get as well. I don't pick and choose. You've gotten the three gentlemen here contain emails that I've had with an applicant about a swimming pool, the back and forth, just so you can see this is what we advised and this is what, and then I try to cover that as a fact on such and such date. An email was sent to the applicant that stated such, XYZ kind of thing. So maybe it's more detailed than some others would do, but I believe it's important you to have all the facts.
oh yeah, definitely want the facts.
Okay.
Any other questions, comments?
Nope, that was good.
Nope.
Now, if somebody does come in and they present a bunch of additional information that we haven't
Being
seen prior,
Mhm.
and we have a lot more questions to, we can then extend it into the next.
Oh, we could, yes, we can always, got the right word for this, but you could
Continue.
Continue, as the word I wanted, it was continue to another meeting, yes.
Yeah, okay,
Yeah,
all right.
continue to-
But if you continue, it would say, I would advise stating the reasons why. We
Yeah.
would like the applicant to provide, that information from the traffic engineer that they indicated.
Right.
Whatever, or, whatever the case may
Right.
be. But so you would continue the hearing.
But it didn't provide a full survey, it provided, some sketch.
Right.
That wasn't adequate enough to really understand what was going on.
Yeah.
So realistically, at the hearing, you're in a position to approve it,
Mhm.
to deny it, in some instances approve with conditions, so it's a special use permit. Or you could continue the hearing to additional time for further additional evidence or deliberation.
Right,
Most of the time, you're going to make a decision
right.
sitting here. But there are times
But there
where
are times.
there are times like I could see like a long cell tower hearing going into.
The worst one I can remember, and I wasn't on board then, was Riverside Drive when they needed setbacks.
Mhm.
They wanted setbacks on everything on Riverside Drive, and I think they got a bunch of them, but not all of them.
Okay.
But that one went on for at least two long meetings, highly attended.
Gotcha.
Yeah, cell
Was it a
towers can
property manager
often
or-
be.
What?
Was it the individual homeowners or was it the
By the
property
developer.
developer? Yeah.
So, but I've 30 plus years doing this. I've had some interesting cases. So
I can imagine.
haven't experienced everything, but I've experienced a lot. So. There are some head scratchers still here or there.
Yes. All right, sir, Ron, thank you very much.
Yeah, thank you, that was great.
Thank you.
Okay, next on our agenda is any administrative items. I don't know of any. Do you have anything for us, Lisa or Karen, Kimberly? No? Okay, I guess we could cross that one off. So I'll take a motion to adjourn then.
I'll make a motion.
Second.
To adjourn, okay. Anyone in favor?
Aye.
Meeting is adjourned. You can shut us, turn on.